What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we are going to be breaking down Karen Reed's answer and, more importantly, the affirmative defenses that she sets out in her civil case against the O'Keeffes. We're going to break down what it is that the answer accomplishes in a civil case, what admit and deny and without information, therefore deny. What does all that mean? Why do we have to do that in the law? Why do lawyers even have affirmative defenses? How do you prove affirmative defenses? What do they mean? Specifically, we're going to go through each affirmative defense and talk about which ones are just kind of boilerplate, not really even going to be applicable to this case. Why would you then add them in? And the ones that are potentially spot on for the defense in this case. Make sure you guys hit that like button. I'm sure you have a lot of questions. You've already been emailing me in a ton of them. We're going to get to all those as well. Make sure you're subscribed. Let's get to it. All right, so as you already know, in the law, there are all sorts of time limitations that you have to do everything. And one of those time limitations is to file an answer to the complaint. If you do not answer a complaint in civil court, you can get a default judgment, which basically means you lose. If that happens in most jurisdictions, most judges, once you get a lawyer on the case, once they try to file something saying, hey, we have a default judgment in this case, we shouldn't have a default judgment, then the judge will let you reopen the case and vacate the default judgment. We don't have that here because we have a situation where Karen Reed did, in fact, file the answer. All right, so let's pull that up and see what it looks like. So here is the answer. This is what it looks like. You go paragraph by paragraph. Each paragraph corresponds with a paragraph in the complaint filed by the O'Keeffes, and you go through and as a lawyer, you answer each and every one of these paragraphs. Do you admit what the paragraph says to be true and therefore we don't have to fight about it, we don't have to litigate it, or do you deny what the paragraph says, and is it something that we are going to have to fight about in this civil action? Okay, so that's the point of the answer and the affirmative defenses at the end. So as you go through each one of these paragraphs, what happens if you admit? What happens if you deny? If you admit it, it is deemed as true, and it is something that later on you can basically force a stipulation on. We'll talk about which ones have been admitted in this case. If you deny it, you are saying it is not true, therefore they need to go prove it. If they end up proving it later, in most circumstances, that's the whole point of this case, is we figure out what can we cut out, what can we not fight about. But there are a lot of paragraphs that have this language. Ms. Reed is without sufficient or adequate information to admit or deny the allegations asserted in paragraph 1 of the complaint, and therefore denies the same. Well, if you don't have enough information to admit or deny, how are you possibly denying it? Well, in most jurisdictions, in most circumstances, in the complaint, just like something called a request for admission, right? That's part of discovery. Most people have heard of interrogatories, which you write out questions and the other side has to type out answers. There's request for production, where you type out either a question or a request for a certain document, and the other side has to produce that document. There's also request for admission, where you can say things like, you were driving under the influence of alcohol that night. And Karen Reed's either going to have to say admit or deny that fact. And those are another mechanism where if you deny it and the other side goes and proves it, there could be potential attorney's fees tacked on top for that. So in that circumstance, just like in a complaint, if you don't admit or deny, it's usually taken as admitted. Now, later there are ways you can go back and say, Judge, I messed up. It was inadvertent. I meant to deny that. Some judges that are sticklers might say, well, too bad. The rules have already passed. The timing has passed. You didn't deny it. Therefore, it's deemed admitted. So that can be a big problem. If you forget to deny something or you just don't answer a certain paragraph, that could be deemed admitted. In those requests for admissions, same thing. If you don't deny it, then it could be deemed admitted. So what do you do with something that you don't necessarily know? If the O'Keeffes say that they did something in the house where Karen Reed wasn't there, how the heck is she supposed to know if that's true or not? So that's why you put in there without sufficient or adequate information to admit or deny, therefore I deny. And as you can see from this, every time there's a long paragraph, that's basically what it says. And then you'll see a lot of denied. There's a couple admitteds, but the vast majority of these paragraphs are denied. And just to give you an example, and if we have time at the end and you guys really want to go through and see, exactly which paragraphs were admitted or denied. Anybody can do that. They're lined up, paragraph 1, paragraph 2, so on and so forth. And Ashley sent me a email with a document attached that is a spreadsheet that was prepared by, and Ashley is in the chat, so correct me if I'm wrong, Ashley. I believe she said it was prepared by the trial channel and posted on Twitter. Isn't the internet, it could be such a great place. I almost said isn't it a great place. It could be a horrible place. And social media can be complete poison and evil, but so much good can also happen on the internet and on social media. We try to use it as a beacon of good, and hopefully a lot of other channels are doing the same, and a lot of other sites are doing the same. And I believe that to be quite a service to people wanting to line this up and really go through it, because people are fully invested in this, and I totally understand that. And the trial channel was like, here's what paragraph 1 says, here's what Karen Reed says in her answer. And that's a really great service that they provided. Gail just said, I just rewatched Poldark. Peter looks like Ross. So I don't know who Ross is. I've never seen Poldark, but multiple people have told me I look like somebody in Poldark. So I wonder if that is the same character. Yes, Ashley said it is the trial channel. It takes a village to help with these trials. But just to give you a little bit of an example here, right? So I'll go ahead and just scroll to the first couple of admitted paragraphs. So you might ask, what are paragraphs 10 and 11? Paragraph 10, which has been deemed admitted by Karen Reed, is after the tragic death of JJ, Margaret took guardianship / custody of her grandchildren, Kaylee and Patrick. And then paragraph 11, at all relevant times on or before January 29, 22, JJ and the defendant Reed were in a dating relationship. Those are the types of things that they admitted. Paragraph 22, on or about January 28, 22, 10:54 p.m., JJ and defendant entered the waterfall. Paragraph 23, at all relevant times, Waterfall was licensed to distribute, sell, or serve alcohol. Sorry, that one's not admitted. That one they have as blank. Let's see. What did they say about paragraph 23? Let's see what this says. Okay, without sufficient information, which makes sense, right? That's a perfect example. She doesn't know if the Waterfall has a license. She doesn't know if the Waterfall can serve alcohol. She assumes, but you don't want to make assumptions. You know what they say about assumptions. Here's one that was admitted. On January 29th, approximately 12:10, defendant Reed left the waterfall. We have video evidence of that. Here is an example of something that they denied. And you get the gist, right, of this. At all relevant times on January 29th, between 12:11 and 12:36, defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. They have denied that. That is paragraph 29. Denied. Okay? So you get the gist of kind of how this works. And again, like I said, if we have time at the end, if you guys really want to, we can go back through, but it's pretty obvious if you've read through the complaint, which ones they would admit and which ones they would deny. Anything that's going to be damning, anything that's going to admit liability, anything that's going to admit causation for John O'Keefe's death, they are not going to admit that at this point. Charlotte said, just a civil law fan here, thanks to Peter. We love it. We welcome you with open arms. And by the way, just a civil law fan, we're cool if you come hang out in the criminal cases as well. I know you have been, and I know you will continue to do so. And Charlotte has also, I have so many friends that name their daughters Charlotte, and they call them all Charlie. And I think that's a really cute name. I don't know why that just popped into my head, Charlotte, sometimes when I saw your name. So thank you so much for gifting 5 Laura memberships. Okay, so let's scroll down here to, I think, the more interesting part. And by the way, you'll notice that the counts that correspond with the Waterfall and CF McCarthy's, they're like, listen, none of this has anything to do with Miss Reed, but guess what? We're still going to deny, because if we need to respond to this stuff, we're going to make sure it's denied. And just so you know, very rarely does this stuff ever come back as a big deal later in the case. Usually we're going to try the case. Sometimes the complaint is a little different than what we're trying on. And, it's part of just kind of the paperwork of a case, and the trial is so many years in the future that a lot of times these types of things never get litigated later unless there's a major issue with them. And before we get to the affirmative defenses, which is going to be a big bulk of this video, I did want to mention a couple things, because I know a couple people, actually, we'll save those for the end if people have questions about some things that were tweeted about and going strong on Twitter today. If you guys have questions on those Massachusetts issues, then we can discuss them later. All right. Having denied each and every allegation pled in the complaint that has not been expressly admitted, Ms. Reed asserts the following affirmative defenses. So they're trying to say here, kind of like a catch-all, if we didn't expressly admit, if we accidentally skipped a paragraph, if it wasn't, clear enough, those are all denied. Those are all denied, just so everybody knows. Okay. The first affirmative defense is the complaint. First off, what is an affirmative defense, right? I'm sure somebody has that question because a lot of people were like, are these different than the affirmative claims that the defense was saying they're going to file against all these third-party defendants? So the answer is yes. An affirmative defense is very different than an affirmative claim. Affirmative claims are nothing more or less than a claim in a complaint or a count or a cause of action, much like what the O'Keefes filed against Karen Reed, C.F. McCarthy's, and the Waterfall. Those are affirmative claims. The defense was kind of mixing them to try and really make these cases seem inextricably intertwined so that they can bring all of those other defendants into this civil case because that is their goal. And so that's the kind of way that they are wordsmithing affirmative claims. Affirmative defenses are different. Affirmative defenses are ways that you fight a complaint, and affirmative defenses at the end of the day can say things like, if everything the O'Keefes said is true, they still lose because of this defense. And usually my guess is Massachusetts is the same as Florida, but to prove an affirmative defense, it's the same kind of standard, like preponderance of the evidence, greater weight of the evidence, more likely than not, whatever you want to call it. They just have to prove basically 51% that this affirmative defense is true to a jury. So an affirmative defense is also different than a motion to dismiss, which we've already talked about it. We've talked about the different reasons you can file a motion to dismiss. We talked about the different motions they filed and different counts they tried to dismiss. In this case, they were successful on one of them, I believe, and not any of the others. So that is also different than an affirmative defense. An affirmative defense, again, is something you eventually prove to a jury that if you believe the plaintiffs proved all of this is true, members of the jury, they still lose because of these things. And something for, all of you guys that have followed, my guess is a lot more criminal cases than you have civil cases. There are affirmative defenses in criminal cases as well. And affirmative defenses in criminal cases, as you'll understand, like a self-defense or an insanity defense or entrapment, which again, the same type of argument applies, that even if what the state proved is true, for example, if I pulled a firearm out and ended somebody's life, the state can prove that. And they can prove that I did it intentionally and whatever. But if I did it in self-defense of my life, and I prove all the, whatever jurisdiction you're in, all the prereqs to prove that it is in fact self-defense and it was reasonable, the force that I used in the circumstance, well, everything the state proved is true, and I'm still not guilty because it was self-defense. Those are the types of arguments you make in affirmative defenses that people can understand. Same thing in an insanity plea is like, yes, you proved all the elements up, but I didn't know right from wrong. I didn't understand what I was doing. I have a mental disorder. Depending on what the parameters are in your jurisdiction, you prove up the affirmative defense as of insanity, and you can still win that case. Okay. Peter, I take my name from the song Charlotte Sometimes by The Cure. Okay. All right. Nina, how can Karen Reed's civil team get the new Proctor texts? Well, they can try. They can try to get them produced in discovery. They can do public records requests. They can request the criminal file in these different cases. If they're not subject to a protective order, obviously, they're going to be easier to get. There are lots of different ways to try and get them. If somebody like Turtle Boy has them, and the plaintiffs has made Turtle Boy part of this case because of the big smear campaign, and they want Turtle Boy to sit for a deposition, they can also file what's called a subpoena ducis tecum, which makes Turtle Boy produce certain documents. These can be some of the documents they asked Turtle Boy to produce. Now, the other side can file a motion for protective order, even if Turtle Boy wants to produce them, basically blocking them from being produced. There's all sorts of things that can happen in civil cases, all sorts of paperwork, all sorts of litigation, all sorts of motions and hearings where judges are going to have to make decisions. So I expect a lot of that. I don't expect this to be smooth sailing for either side. Okay, so let's get to affirmative defense number one. The complaint fails to state a claim upon which relief can be granted, and accordingly, each count set forth therein should be dismissed with prejudice. This is probably more appropriately a motion to dismiss. This was one of the arguments they made on their motions to dismiss for the emotional distress claims. Catherine said, Peter's giving my brain a workout on my day off. Sorry, Catherine. This stuff I love being in the weeds on this stuff. This stuff is really fun to me. And I know you guys have a lot of questions about it. So I want to dig in. I want to get to it. And I want to discuss it with you so everybody can hopefully understand when these things get filed. And when other people maybe on Twitter that have never, gone to law school before say certain things or try to pull certain things out as, oh, this is big and this is what it's going to mean. Hopefully we can give a little reality check here and what's important and what's maybe less important and why they file things like this. So this is basically what they argued as the motion to dismiss. I would say it's probably more appropriate to file this type of argument under a motion to dismiss, because basically what it's saying is, even with all the allegations, even everything they say in this complaint, if it's all true, there's still no claim. There's still no cause of action. There's nothing that Karen Reed can get dinged for here with civil liability, even if everything you say is true. I personally think this is a losing argument. I don't think we're really going to hear much about this again. I think we already heard their arguments on the motion to dismiss. They didn't even apply it to the wrongful death car accident part of this. They only applied it to the infliction of emotional distress claims. I think we've already heard any argument we're going to have for failure to state a cause of action. So again, this is kind of a nothing burger to me as far as affirmative defenses go. If it would have been a successful motion to dismiss, then bada bing, that's important. All right. The second one is, to the extent plaintiff has suffered damages, all such damages claimed were caused by acts and omissions by third parties for whom Ms. Reed is not responsible. Do you guys think this one's important? Do you guys think this one's important? So, third party culprit. That's basically what this affirmative defense is. And when you're looking at it in the civil realm, it means we agree that the plaintiff has been caused damages. John O'Keefe's life was taken. We agree, by either the intentional or negligent act of somebody else. But it is not the defendant who is responsible for the plaintiff's injuries or losses. This is the affirmative defense. It's a causation argument, right? That I didn't cause his injuries. Yes, I may have gone out with him. Yes, I may have gone drinking with him. Yes, I may have driven him in my car. Yes, I may have dropped him off at 34 Fairview, but I did not cause the injuries. This is the affirmative defense that makes everybody else that Karen Reed wants to bring into this case. This is what could potentially make them inextricably intertwined and a vital part, an essential party to this litigation, that if we have to file a separate claim, judge, if I'm the defense, and if we have to file a separate claim, judge, in another jurisdiction, another court, this affirmative defense is why we are going to have discovery duplicated. And we're going to have to do everything twice. Requests for admissions, interrogatories, requests for production, depositions, subpoena ducis tecum to all these separate witnesses. And it's going to make it more difficult for us, judge, to get the documents in this case for somebody that's going to be a party in another case in another jurisdiction, as opposed to Your Honor having the authority and jurisdiction over these parties to force them to give us documents. This is the one. Okay, this is potentially the most important affirmative defense in my opinion. Because, like every jurisdiction in Massachusetts, a defendant is only liable for what they cause, which is, of course, how it should be. And if somebody else caused these damages, because there are certain things where it's like, was it foreseeable for the defendant to notice that this person was going to get injured if they dropped them off or left them with third parties? And in reality, if something is not foreseeable, then it can't be held against a defendant. And if a third party did something to John O'Keefe, either purposely or accidentally, and again, does Karen Reed know what happened? Is she going to be able to prove what happened? I don't know. But the point is, she's like, I didn't do this, which means somebody else did. And it's not foreseeable for me to know or should have known that somebody else was going to do this to John O'Keefe. Okay. Next up is the doctrine of waiver. And most people probably know what this means. It basically means that the plaintiff has waived the ability, given up the right. Usually it has to be explicit. If it's implicit, you still need to be able to prove that they have, in fact, waived their right to file this claim against a defendant. This is something that I would call a boilerplate affirmative defense and a situation where you're just kind of throwing everything at the wall, thinking it may come up later, I don't expect them to have a good argument that the O'Keefes have waived their ability to file these claims. Okay. And to give you an example of a waiver, most of us have been to theme parks. If you sign a waiver saying, I'm not going to sue you X, Y, and Z, by the way, there's lots of ways to get around those, and theme parks try to pack way too much into those, and they still do things that are outside of whatever their waiver is. But generally speaking, if it's a good waiver that is going to hold, that would be an example of a very strong affirmative defense. And I would, by the way, you have to have a good faith basis to file these affirmative defenses. And many times my firm will file, because we're usually the plaintiff side, motions to strike affirmative defenses if there's no good faith basis to have of an affirmative defense. And the defense will have to provide reasons and why. Do you have a good faith basis for this? And if you have a waiver that's been signed by the plaintiff, that's a pretty good faith basis to have this affirmative defense. So that's an example of where waiver would apply, and I just don't think we have it here. Beth asked a good question. Isn't every defense an affirmative defense? No, it's not. In criminal cases, they can't prove it is not an affirmative defense, right? But in civil cases, examples would be causation, meaning this person has a pre-existing injury. Let's just say it's a back injury where they have a herniated disc and they end up getting a surgery. One of the defenses is causation. We didn't cause this injury. Yes, we caused the accident, but that accident could not have caused this injury. It was a fender bender, a side swipe, and that mechanism of injury could never cause a disc to be bulged, herniated, whatever, right? Whatever the argument is going to be. That's not an affirmative defense. That's just a regular defense. Or these damages are too high. They're asking for all this money. Give me a break. This is what the bills should be. That's a defense. Something the defense can argue. Not an affirmative defense. Or shared liability. Like, hey, we're both driving. We both had flashing yellows and we got into an accident. We're both liable, 50-50, whatever it may be. Or the other person's liable. So not everything is necessarily an affirmative defense. Nina, are they new co-defendants or new defendants? How can the plaintiff call them as witnesses if they are now co-defendants? It sounds very complicated. Yes. Number one, it is going to be very complicated. They would not be co-defendants. They would be, it's not really counterclaims. I guess it'd be cross-claim defendants because they're other third-party defendants. So they would have like cross-claim plaintiffs and cross-claim defendants. It would be very complicated. They would not be co-defendants because the O'Keefes would not be suing them, and they're not on the same side necessarily of the V with Karen Reed. It's unusual. This is not something that, this isn't normally how you would do it. Not normally how you do it. Peter, what is that design on your shirt driving me nuts? I would say it's flowers and leaves. This is the shirt Maverick got me for my birthday. So he had a flag football game today and I wore it to the game. And he's like, oh, it's the shirt I got you. I was like, yeah. So that's why I'm wearing this shirt, and that's the design he picked out on it. It's very Florida-y. Okay. Okay, we hit waiver. Let's go to estoppel, right? So the doctrine of estoppel, what is that? Well, this is usually how you estop somebody from doing something, from taking legal action because of something they did in the past. There is equitable estoppel and promissory estoppel. I don't do a ton of this work because I'll spoiler alert it for you. This is also something I don't expect to be something seriously litigated or something seriously relied on by Karen Reed and her team. Now, by the way, take everything I'm saying here with a grain of salt, because something we always say, we don't know everything in these cases. There's a lot that goes on beyond and behind the scenes and beyond what we can see. The lawyers obviously know so much more about this case than I do. So maybe there is something that fits waiver or fits estoppel that we haven't discussed or we haven't thought about yet. That's very possible. So equitable estoppel is just basically, this isn't fair. And it's something that you've done or said in the past that you kind of try to dupe somebody. Like landlord tenant is something this happens a lot in, where you're like, oh, it's okay if you don't pay the rent right on time. And then they miss rent by a day and you're like, boom, evicting you and keeping your deposit. And it's like, but I have a text message where you said it was okay if I didn't pay rent on time. You can't do that. And the courts would usually stop that. Promissory estoppel is you make some kind of promise that causes somebody else to do something that wastes their time or money, or, damages them somehow. For example, maybe I'm like, Charlotte, sometimes will you build me this table? And you go out and you buy all the materials. Then I'm like, actually, never mind. And you're like, well, I just spent $1,000 on these materials. So what's going on now? So things that you do or say, and then you flip it around and you try to screw somebody else for it. That's usually what estoppel is used for. I've never seen it really used in car accident, wrongful death cases before. All right, next up is latches. Okay. This is basically, we're going to talk about statute of limitations as well. We can kind of take these combined, but it's basically you waited too long to assert your rights. You caused some unreasonable delay as the plaintiff. And in this case, I don't think they have this argument because the plaintiff's the one that's been wanting to push it. The defense, if anything, has been slowing it down. There was obviously the criminal case. And from my perspective, the criminal case is always an appropriate delay. Usually civil courts will think that's perfectly fine. Statute of limitations, again, is another one. I believe it's 3 years in Massachusetts for a wrongful death car accident case. I think it's 3 years for the emotional distress claims as well, whether they're negligent or intentional. And I believe all these were filed within that 3-year period. And it's when it's filed, not when it's tried. If you guys have cases on the or questions on those, we can talk more about it. But I think most people know what a statute of limitations is and what those issues are. Okay, here's the next one. The claims are barred by the doctrine of unclean hands. And I saw some people and people had questions about me or to me about this saying, ooh, this one looks good. Doctrine of unclean hands. Can this apply to Higgins and the McCabe's and Alberts and everybody else? Does this apply to the O'Keefes? Does this mean they know something that the O'Keefes did that we don't know about that's going to bar them from having these claims? Okay. So the doctrine of unclean hands, latches, unclean hands, estoppel, waiver. Waiver actually sometimes does come into play in these kinds of cases. So I'll leave that one out. Latches, estoppel, and unclean hands, usually, I think those are the only ones, are really not something that I ever see in car accident, wrongful death cases. So from my perspective, I don't expect them to be a big part of these cases, but doesn't mean they can't be. So let's talk about unclean hands and what it actually means. Usually unclean hands, again, is a type of equitable defense. And what equitable defenses means is it stops you from being able to do something. It's not usually here you get money for these types of defenses. So is estoppel similar to detrimental reliance? Promissory estoppel can be similar to detrimental reliance. There are civil causes of action for these things as well. Like I can sue, or Charlotte can sue me for making her spend that $1,000 where I have to pay her that $1,000 back. So yes, you can do things like that. She detrimentally relied on my promise. So there are different ways to do it, but there are different causes of action in different jurisdictions. So they're not always exactly the same. Okay, so let's talk about unclean hands. Basically, this is a situation where a plaintiff acts unfairly. They do something in bad faith, or they lie, or do something wrong, which can sound really juicy. And usually it's the plaintiffs that have to do this. So this doesn't usually apply to third parties. So if we, find out something later that the O'Keefes did, then maybe it comes into play here. But what the Proctors of the world and the Tullys and the Higgins and Alberts and McCabe's, what the defense thinks they can prove that they did or knew, and maybe they can prove they have unclean hands in all of this, does not necessarily apply to the O'Keefes. Of course, if the O'Keefes were in it, if they told them to do it, fine, then maybe we can have something there. But also, this would, and I'm going to give myself a caveat, right? It's all lawyers do, is caveats on top of caveats. And always it depends, but I feel like I have to explain this with full context. But let's just stick to the car accident, okay? The car accident, the wrongful death that they're suing under here. The defense would have to prove the O'Keefes had unclean hands with regards to the car accident, or not even the car accident, but just the taking of John O'Keefe's life. So let's say there was no car accident and John O'Keefe died, and the defense is trying to prove that the O'Keefes had unclean hands, meaning they did something, lied, acted in bad faith with regards to John O'Keefe's death. I think that's going to be very hard. I don't think that that's going to be anything that they can prove. I think it's a very big nothing burger. But then we have the whole Turtle Boy situation and the claims that there was this scheme to push a false narrative that the plaintiffs are filing that make this all so much more complicated for them. I never would have filed that. If I felt like I had evidence to prove a car accident that Karen Reed hit John O'Keefe, fine. Car accident, wrongful death. If you feel like as a lawyer you can prove that by a preponderance of the evidence, and the only reason they lost in the criminal case is because the burden of proof was too high as beyond a reasonable doubt, fine. But did the O'Keefes have unclean hands when it came to the false narrative and the media scandal or whatever you want to call it? Maybe they have something there. At best, I think it's a reach. I really think the doctrine of unclean hands is a nothing burger. And maybe that's not what people want to hear. Maybe that's not what other people are saying. I'd be happy to have discussions with people about it. I really think that this is a complete nothing burger when it comes to the O'Keefes having unclean hands, the O'Keefes themselves. And just to give you an example of sometimes unclean hands, usually it's like injunctions where maybe you have an injunction against your boyfriend and then you drive to your boyfriend's house. He can't be within however many feet of you. You go inside his house, then you call the cops and you're like, oh, he violated the injunction. It's like, come on, you did that. Other examples would be you sometimes even in like contract situations where you breach the contract and the other side breaches the contract because they stop working. And then you try to file a lawsuit against them because they stopped working. And they're like, well, you breached the contract first. And then are you committing some kind of fraud or, dishonest behavior or acting in bad faith? That could potentially be unclean hands in this situation, which again, very, very unusual for it to be involved in a car accident, wrongful death scenario, which is what we have here as far as the claims made by the plaintiff. All right, next. The next affirmative defense is any damages that the plaintiffs claim that they are entitled to are expressly limited by Massachusetts law, including the limitations on damages set forth in MGL C229 Section 1 et sec. So this is another one that to me is more appropriate for potentially a motion to dismiss. And it is also something that they filed in the motion to dismiss. If you remember, they're like the intentional infliction of emotional distress damages are encompassed by the wrongful death statute. Therefore, they shouldn't be entitled to those damages. We have already kind of seen that argument. Like I said, the judge did not agree with it. I don't think it's going to really go any further than that. I think this is also a nothing burger when it comes to the complaint in this case. All right, let me see what questions we have before we get to a couple more. As the plaintiff, what would be your next move? So I would file a motion to strike the affirmative defenses that I thought were either irrelevant or inappropriate for this type of case. I would ask them to give us some kind of good faith basis, some kind of factual basis for these affirmative defenses. What information do they have? I think they're absolutely going to have a huge factual basis for the third party, right? Being responsible for this, and maybe a couple other ones I think they will have a factual basis for, but I think there are some that might get struck immediately, and you want to do that because as long as these affirmative defenses are out there, it opens up discovery questions, because in discovery, you are allowed to ask for and force the other side to produce anything that could reasonably be believed to lead to discoverable material. And I keep making my hands wider and wider as I say that sentence, because what's admissible at trial and what's relevant is so much more narrow than what can be provided in discovery, especially when you compare criminal discovery in Massachusetts versus civil discovery. In Florida, for felony cases, discovery is really wide for criminal felony cases at the state level. Federal level, no. It's a lot more like Massachusetts where you can't do a lot. But comparing how much more broad the discovery is going to be in this civil case than we had in the criminal case for Karen Reed, as long as it's reasonably connected to an affirmative defense, that I'd be like, Judge, I have to prove this affirmative defense. Therefore, I need this discovery. That will help your argument and make it go a long way, which is why, as the defense, you want to dismiss as many of these claims as you possibly can. They got one dismissed, so that's going to limit discovery at least a little bit on that claim. But anything that could even reasonably believed to be discoverable material in every single cause of action that exists on every one of these causes of action, they're going to be able to get discovery on those topics. So any topic you can cross out, because lawyers, we're crafty folk. We're going to be like, oh, Judge, maybe this affirmative defense, like statute of limitations, we need to see Proctor's text back 3 years. It's like, that's not really how that's supposed to go. Michelle said, you may be just a civil lawyer, but today I learned I never graduated from high school. Do you think the judge will allow Karen Reed to combine the cases? I'm assuming you're talking about maybe from a Twitter troll or something. Oh, you'd be surprised what they say to me. Maybe you wouldn't be surprised what they say to me and about me. But the mute button is just such a beautiful thing. Best thing Twitter ever created. I don't like to block people. I like people to be able to mix it up and ham it up if they want to in my chat. And I love seeing your guys' responses to the trolls. It like warms my heart. But yeah, I'm not interested in getting involved on it. And sometimes I'll just pass completely on reading comments. But I don't know. If I were to guess, I would say no. I'm just leaning towards no because it's going to make his case so much more complicated. But I would say potentially like, listen, the discovery you get in that case, I'll let you potentially add it in here. Maybe I'll take judicial notice of that case so that all the evidence in that case can automatically come here. I'd try to craft ways to make it fair. If I had to guess what he's going to do, I would guess no. How often do civil trials end up with this many parties, and how long do you think this one will last? 3 or 4 parties like this one, C.F. McCarthy's, Waterfall's, O'Keefe's, and Reed, that's no big deal. That all the time that we have 3, 4, 5, 6 parties, multiple people, employer, employee, that's nothing. But to have another 10, you get to 15, 20 parties, then it gets kind of miserable. Lisa, thank you for gifting 5 Lawyer memberships. All right, let's keep reading, and then we have a bunch of questions coming in, which I love it. I love it. Let's get through these last 2, and then I'm going to answer a bunch of questions. So if you guys have questions on this or questions on other topics that have been coming out on Twitter in Massachusetts, I will comment on them at the end of this video. All right, the next one is plaintiffs failed to establish that they are entitled to punitive damages as claimed. So different jurisdictions handle punitive damages completely different. In Florida, you can't even allege punitive damages in the complaint, meaning I can't say we are entitled to punitive damages, judge, and that's what we're asking for in the wherefore clause. I can't even say that in Florida until and unless I can prove it up, meaning I do discovery, I take depositions, and I get enough information that what we say in Florida is a reasonable showing by evidence that we are entitled to punitive damages, and I have to file a separate motion for entitlement to punitive damages and to amend the complaint to add punitive damages. And I have to draft a new complaint, submit it to the judge on the other side so that they can fight and argue we are not entitled to punitive damages. And if we win, then we get to amend the complaint and add punitive damages later. A very complicated process, which I don't necessarily mind because punitive damages is such a leverage point. And once we win that argument, you better believe the defense usually comes to the table with a bigger number. Because we're like, even the judge sees we have a reasonable basis for punitive damages, and we're going hard. We're dropping the hammer. Recently, it settled a 7-figure case for us that they didn't really come to the table until we won that motion and amended the complaint. But in Massachusetts and other jurisdictions, there are certain cases, statutorily or otherwise, that you are allowed to allege punitive damages, and others where you're just absolutely not. And it seems as though a wrongful death car accident claim is a claim in which you can get punitive damages, especially, or I guess if it is intentional, reckless, wanton actions by the defendant that causes the death. And in this case, drunk driving recklessly or getting mad at him and intentionally hitting him with a car would fall under, as it seems, I'm not an expert on Massachusetts law. I have had plenty of cases in Massachusetts, and we have dealt with this issue in Massachusetts before. Because we have lawyers barred in multiple states, we can waive in. There's pro hoc vice, just like Alan Jackson's from California, pro hoc into Massachusetts. We do that as well all over the country for car accident, wrongful death claims, just like this, trucking accident, different kinds of wrongful death cases, just like this, which is why I know different jurisdictions handle these things differently. So it seems like punitive damages are appropriate. And they're also appropriate for intentional torts like intentional infliction of emotional distress. So it is a leverage point for the plaintiff to ask for punitive damages. I'm not even sure I remember reading their request for punitive damages or attorney's fees and costs, which we're going to read about next in the complaint. Maybe they were there. But anyways, so I think that this is a scenario where they appropriately asked for punitive damages. I do not think the punitive damages are going to be struck at this stage. We'll see. So again, something that I don't think is necessarily going to be successful for Karen Reed. Lastly, no entitlement for attorney's fees and costs. So plaintiff failed to establish they're entitled to attorney's fees and costs. So this is, again, similar to punitive damages. There are certain statutes that say you can be entitled to attorney's fees and costs. We used to do a lot of FLSA claims, the Fair Labor Standard Act. You don't pay somebody minimum wage or you don't pay them overtime. We can sue you as the employer. And guess what? Because our client usually doesn't have enough money if they're a minimum wage worker and you're a big corporation company, David versus Goliath situation, you could just bleed our client dry if they had to pay me attorney's fees, or they would never be able to hire me in the first place. So therefore, the statute says you have to pay my attorney's fees if we win. So I'm working for free basically for this person because you screwed them. And when we go in, and by the way, when we get a settlement, we tack attorney's fees and costs on top of it. So that's statutory attorney's fees. There are also situations where statutorily they provide prevailing party attorney's fees. So if whoever wins, whichever side wins, the loser has to pay the attorney's fees. Another one is contracts, right? A lot of contracts. And I always, when I don't like to write contracts, sometimes, of course, I get roped into doing it for friends or people I work with or companies that I'm friendly with or whatever it may be. They'll hire me to write a contract of some sort with them. I have a couple buddies that are like agents to NBA athletes, and they have me write certain contracts for them, just kind of fun, right? Doing work for NBA and NFL athletes. I'm a big sports fan, so that's kind of fun sometimes. So I've done it with them. I love to put prevailing party attorney's fees in. Don't screw up, because at the time, nobody thinks they're going to be the one that screws up. They're never thinking they're going to do something to breach the contract. They're never going to be the bad guy, right? And I want the good guy to win. And I want there to be leverage on the good guy's side. So, and I don't want just rich people to win lawsuits. And they're the only ones that can ever hire lawyers. So attorney's fees provisions, especially for prevailing parties, help the little guy. They give access to the courts, to the little guy, to everybody in America. And that's something we fight really hard for in a lot of the organizations that I'm a part of. And attorney's fees can be one of those things. Just think about it. Like, if you're rich, you hire better attorneys. Great. Well, what if the rich guy's also paying the other attorney? Well, now they can have the best attorneys too. So sometimes in contracts, there will be a provision where it says, whoever loses is going to have to pay the other side attorney's fees and costs. I don't see necessarily a claim for attorney's fees and costs or how they're going to get it. So this is something that could become something they argue about later. But there are also, we've talked about it on this channel before, proposals for settlement, offers of judgment. There are also mechanisms that you can use, tools you can use in the law that create the opportunity for attorney's fees. We've talked about proposals for settlement. They're a little different in every jurisdiction. So I'll just tell you Florida's. If I do a proposal for settlement for $75,000, actually, let's go with $100,000 to make it simple, and you say no, and I go to trial and I beat that proposal for settlement by 25%. So I go get $126,000 for simple math. Now you have to pay all of my attorney's fees and costs, even if you wouldn't have had to before, that I have racked up since filing that proposal for settlement. And the reason for that is I was being reasonable. I told you, come settle for $100,000. You said no. You were being unreasonable. You forced my client to go to trial, to spend all this extra time on fees and costs because you were unreasonable and the jury said so. So I get $126,000 plus the $500,000 in attorney's fees and costs I billed hourly. Okay. So those are different ways that you can get attorney's fees and costs that may come up later in this case. We will have to wait and see. All right. So there was something I was going to say here. Oh, Ms. Reed expressly reserves the right to assert additional affirmative defenses as this matter proceeds. So there are different jurisdictions that have different rules that you can file affirmative defenses later. You do more discovery. You find out about a new affirmative defense. It has to be within a reasonable time period of you finding it out. So we may see more affirmative defenses later. Sometimes they will be barred though. All right. Let's get to some Q&A because I have a feeling you guys have some questions about this and maybe some other stuff as well. Dever is back with an email. I don't know what Dever is back with an email. I should have read this one. An email from the FBI to the Commissioner Cox, yet he denied it all. And we said this when he came out with that statement. Somebody's not telling the truth, either Dever or Cox. And maybe somebody would have liked to have given Cox the benefit of the doubt since Dever's already admitted creating false memories. Well, it sounds like there's some corroborating evidence that Dever was telling the truth and Cox wasn't. Mish said, Peter, have you seen the Cox email about Dever? How does it look for a commissioner to lie about something so minor? Could that be used in a lawsuit at all to show the thin blue line or law enforcement culture? I would sure like to use it. This is what you guys do. You cover for each other. You tell people to do the right thing. You were trying to get Karen Reed, and it trickled down to Proctor, who was running the ball on the case. I think it's at least something that reasonably is believed to lead to discoverable material, wouldn't you think? I want to take some depositions from Commissioner Cox, from Dever, from Proctor, from Tully. I want to do that. Is Karen Reed team still trying to add the 8 to 10 parties to this case? Yes. As far as I know, yes. Joanne, just when I think I have learned, now there's more. Taking notes. Thanks, Peter. You are the best. Hey, one of the main reasons I like doing this stuff is for you guys to understand how the court system works. And it's not just the criminal courts. How many people, raise your hand, have been involved in the civil justice system? Probate, family law, injunctions, contract disputes, car accidents. I want you to know how all this works. I want you to be prepared. I want you to not be scared. If you did nothing wrong, go fight it if you can. If it's worth it, right? I want you to know how this stuff works. I don't want it to be daunting. I don't want it to be scary. And I don't just mean scary for kids. Like, it's scary for adults too. And I have to be honest with my clients, like, this is going to suck. It's going to take so much more time out of your life than you ever imagined. So be prepared. Unclean hands equals O'Keefe fixing John O'Keefe's traverse. So here's what I'll tell you, Michelle. I don't think that would win an unclean hands argument that for the causes of action and the damages they're talking about here. Because did that cause the death of John O'Keefe? Now, maybe they can wrap it into, I would say that's a different cause of action. That's a counterclaim for, I don't know what it would be. I'd have to look for, tampering with evidence, trying to pin it on her or something. But I'm not sure that was unclean hands and causing the damages. Maybe it'll be wrapped into the third-party culprit. Lawyer, will the lawyers get a bite at the apple to see the texts? I believe that there will be mechanisms that they can do that. Yes, I do. Lynette gifted one lawyer membership. Thank you so much, Lynette. Yeah, the best advice is to stay out of court if you can. I agree. Realize. And I always say nobody really calls me when they're happy, if I'm being honest. And I have a lot of people call me from this YouTube channel, from the chat. I absolutely love to talk to you guys and help you guys if it is at all possible in any state and jurisdiction I can possibly help you in. I love it and I want to, and I love when we talk and we skip 6 steps that I usually have with new clients, getting to know each other, building camaraderie, building trust. So I do love that, but none of you guys are happy when you call me. Sometimes you're like, oh, it's so cool to talk to you on the phone. I had this car accident case, or my cousin got hit by a car driving in a crosswalk and I'm able to help, but nobody's ever really happy about the situation they're calling it. And I don't say it's going to be fun. We're not going to become friends and hang out and be besties. I'm going to fight hard for you. My firm is going to fight hard for you. That's what this is going to look like in an attorney-client relationship. Jennifer, the DA just dropped one of Turtle Boy's cases. Yes, I did hear this. Mark Betterow coming in with a king move, right? Because the facts of the case sometimes don't even matter. If you're so bad at prosecuting the case and doing an investigation and everything's so dirty and mucked up, and if you can get the victim in a situation where they're suing everybody, right? What I know about this case is just Betterow telling me like they're having major problems. He was very confident about this one. When we talked a little bit about the DA being disqualified here, I was like, what? How are they even doing X, Y, and Z if they're disqualified on this case? And they admit that they're disqualified. So really, really great lawyering. And if you want to know what a great lawyer can do for you, they can't change the facts of the case, but they can dig, they can fight for every inch. Al Pacino in Any Given Sunday. That's what they do. That's what they do. Does the Proctor dump open the door to personal phones of other officers in civil case? Not necessarily, but it's possible. It's possible. I guess I could pull this up, right? I think I tweeted it, so I should be able to pull it up here. Just a couple notifications. All right. Yeah, let's pull this up. And this was posted by Marbury versus Mad, which is a great account on Twitter. I'm pretty sure we've DM'd before. Let me. So here's the email that says, this is from FBI.gov, Stephen Keller to Michael Cox at pd.boston.gov. Sir, hope all is well. Just a reminder, the documents were released to the DA's office late last night. The officer we spoke about is Kelly Dever. If you have any questions at all, feel free to call me. Steve. February 22nd, 2024. Now, maybe Commissioner Cox is going to be like, hey, I don't check my email every day. I never check my email. I didn't see it. Nina, can you please cover the Sonia Massey trial? The cop shot her in her house, all on body cam. Trial started yesterday. You guys let me know. If you guys are interested in it, then we can take a look at it. I haven't seen one bit about it, but I love getting in early, right? I hate jumping in 5 days into a trial. Song Bits Laura, welcome to the membership crew. Miss Vicky, Maverick picked a great shirt for you. I agree. I think he would too. Peter, will the Proctor cell dump be an issue now with all MSP? I wouldn't say with all MSP, but it could be. It could be. Stephanie, how'd they get that? I believe the poster on Twitter said public records request. So it's out there. And by the way, on civil cases, when something like this happens, you do that for everything. There's going to be a crap ton of documents for them to go through. Sadia. Hey, off topic. Will you cover Koberger trying to avoid paying the victim's family's restitution? Yeah, good luck. Good luck. There may be some legal arguments, but at this point, you get the generally bad guy rule applied to you. So highly doubt it. I haven't seen much on it. If you guys are interested, I can do a video on this for sure. I'm a lurker since Depp v. Heard. That's awesome. That's a long time, Song Bits, Laura. Long time listener, first time caller. Aaron, 10-second break from Karen Reed. How you feeling about the Bucks? Sorry to spoil it the other night with Evans. Figured you were getting updates while doing the live stream. I had watched a little bit, then I went back later. It's brutal. I love Mike Evans. Love Emeka Egbuka. I think he's my new favorite player on the Bucks. Knelt down, prayed for Evans right in the moment there, which was awesome to see from my perspective. I love to see that. He seems literally amazing. I love Baker Mayfield. I love the Bucks. This Bucks team is so incredibly fun. You guys know, and I know people have their feeling about Jameis Winston, one of my favorite players of all time, Florida State, Heisman Trophy, National Championship, undefeated seasons. We went Jameis Winston, Tom Brady, Baker Mayfield. In my mind, I don't know if there's ever been a better trio of quarterbacks to go through any sports team I've ever been a fan of in my entire life, back to back to back. So I'm feeling great about the Bucks. They're a really fun watch. And so from my perspective, I love it. Mario said the Sonia case is not televised. So those are really tough for me to cover. I mean, all the Delphi stuff, even now people talking about Delphi, it's just so hard for me because I wasn't able to watch it with my own eyes and listen with my own ears. Tez Johnson season. That's right, baby. That's right. Ryder Kitty, thank you for all your lawyering. Thank you. Thank you to everybody who shows up for these things that so many people outside of our community would think is so boring, reading a document, talking about an answer in affirmative defenses, but we find it fun and interesting. And it's because of you guys. It's because of your questions. It's because of your interest that there's even a platform to do this on. So I love you guys for coming, hanging out with me. I always appreciate it so much more than I can just say in words, right? And the way I show my appreciation is continue to dig in to try and make these videos as entertaining, educational, fun even, and informational as I possibly can without boring you to complete death. Yellow Ledbettero, does this mean Turtle Boy is no longer out on bail? I don't know that question again because I'm not an expert on those cases, but I think he's got more cases than just this one. I think this was one of a couple cases that he has going. Okay, that's all I got. Hopefully you guys have hit the like button by now. If you haven't, take a second, hit that like button. Make sure you're subscribed and let me know what content you guys are looking at. Because Ashley's sending me all the stuff on these cases. You guys feel free to follow suit. Send me what you're looking at. Send me what you're watching. And that'll be the content we handle. Hey, Peter, I sent you a message on Instagram about sentencing today for the guy who caused my cousin's death. Law tubers are making a difference. Whether you know it or not, keep it up. I read that, A Skier's Daughter. Thank you so much. I absolutely love those messages. I love when people are telling me it's helped them in their own real life. I got a message from a young man the other day that was a kid. the other day that said he was so scared to go into this custody battle for his parents. He watched my YouTube channel, saw what court was like, what lawyers are supposed to do, what judges do. So he wasn't afraid anymore to go in there and fight it. A buddy of mine he knows his parents or whatever. He's a firefighter. He's like, sign this app for him. I signed it for him, gave it to him, sent him a little video. It was amazing to see that stuff happening. One little thing at a time, one person's case at a time. I absolutely love it. Thank you guys so much for letting me know that happens, because you don't even have to tell me that. You don't have to send your thanks. And I love that you do and appreciate that you do so much. All right. That's all we got. I'm starving. It's like dinner time for me. Hope you guys have an amazing Wednesday, amazing hump day. Push for the rest of the week. Peace out. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.